So we're going to look at the franchise agreement. What does it look like? What's its purpose? And why have it? The first key point to note about a franchise agreement is that unlike many other commercial agreements, it is by necessity one-sided, in favour of the franchisor. This is in order to protect the franchisor's trade secrets and ensure quality controls are observed, thereby minimising reputational risk. It is essential that a franchisor has robust protections in place to ensure that the secrecy of its confidential information is maintained and that the quality standards that it wishes to have associated with its brand are upheld at all times, not only for its own benefit, but also for the benefit of the rest of its franchise network. This does not mean, however, that there cannot be some checks and balances on the franchisor's discretion in the agreement to ensure that it acts fairly and equally with all of its franchisees. And this principle is promoted throughout the British Franchise Association's Code of Ethics. Equally, it is to be expected that where there are provisions in the agreement which relate to the quality of the service or adherence to brand standards by the franchisees, these must be non-negotiable due to the reputational risk associated with a failure to observe these. Therefore, most franchise agreements are not only one-sided, but also tend to be lengthy in order to be as comprehensive as possible. Most franchise agreements are issued as non-negotiable by franchisors. This is in an effort to ensure that as far as possible they have contractual uniformity amongst the franchise network. Again, this helps to promote fairness and equality in line with the BFA's Code of Ethics, as it also minimises the potential for discontent between franchisees. Franchisees talk to each other. If someone's got a better deal than someone else, inevitably there are going to be arguments. It also helps to keep costs down by avoiding individual negotiations. But franchisors should understand why the provisions that are in the franchise agreement are there and be prepared to explain these to prospects. An FAQ sheet at the outset helps to manage expectations and also to reduce unnecessary questions and negotiations. Franchise agreements, as I've said, can be extremely lengthy, but they are also supplemented by an operations manual. This is the living part of the agreement. It's the document that actually contains all of the franchisor's operational know-how. It forms part of the franchise agreement, but the franchisor must be free to update this on an ongoing basis in order to keep up with changes in the system. Those updates to the operations manual have to be accepted by franchisees and have to be acted upon. Therefore, there is clearly scope for a franchisor to introduce some substantial changes. And a franchise agreement should provide the assurance to franchisees that in the event of a conflict between the agreement, which contains all of the contractual rights and obligations, and the operations manual, which should really relate purely to the operational side of the business, the franchise agreement prevails. So why have a franchise agreement? This is because there is no franchise-specific law in the UK. So the default position in the absence of a comprehensive contractual agreement can be uncertain. Therefore, in order to avoid argument and ensure that the franchisor and the franchisees' respective rights and obligations are clearly understood, a comprehensive, well-drafted agreement is essential. This can save headache and unnecessary costs in the long run. Franchisors should, and also franchisees should, take franchise specialist legal advice on the franchise agreement at the outset. There is a well-established body of franchise practice and case law in the UK, and any BFA accredited solicitor should be well versed in this and able to draft the agreement accordingly or advise on why the provisions are there for prospective franchisees. This helps to minimise negotiations and manage expectations. Obtaining a review of the franchise agreement from a solicitor experienced in franchising should form part of any due diligence process and should be encouraged by a franchisor, regardless of whether the franchise agreement has been issued as a non-negotiable document, or whether the franchisor is an existing member of the BFA. The BFA has a list of approved affiliated solicitors who should be able to advise on how standard the agreement is, whether it conforms to the BFA's Code of Ethics, and whether there are any glaring omissions or unusual provisions that may require investigation. A robust agreement provides both protection, but it's also an indication of the franchisor's commitment to the business and the franchising. The agreement is a good indicator of how a franchisor is prepared to stand behind the actual franchising of its business concept and its success, A well-drafted agreement prepared by an experienced law firm is not an insignificant investment. So it operates as a marketing document, quite apart from being a legal document. A well-drafted agreement gives a franchisee that level of reassurance that the franchisor is committed. So the franchise agreement contains some key important provisions that the BFA's Code of Ethics would expect to see in there. Firstly, what is the franchisor actually contracting to provide? It's got to give access to its know-how. It's got to grant a license and use of its trademark, confidential information and other intellectual property for the duration of the agreement. It should provide access to its operations manual, which should contain all of the operational details essential for the trading of the business. It should provide training in the system, both at the outset and then periodically when new developments are made. And it should provide support both in the early stages and the initial launch of a business, and then on an ongoing basis to support the franchisee in the business. If that level of ongoing support is not provided, it's not a franchise. If the franchisor is supplying goods and services, then there should be a clear commitment on the franchisor to actually deliver this in the agreement, and also what happens if the supply is interrupted. What is the franchisee contracting to provide? The franchisee is under an obligation in the BFA's Code of Ethics to act loyally and collaborate and cooperate with the franchisor for the duration of the term of the agreement. This means that the franchisee has to adhere to the system standards in operating the business, work with the franchisor in developing improvements to the system, but also to use best endeavours to promote and maximise the turnover of the franchised business. This is not only for a franchisee's benefit, but also for the benefit of the franchisor, who tends to take a management service fee on the turnover of the franchised business. The key respective responsibilities that each party has to have in the franchise agreement have been considered and elaborated upon in the BFA's Code of Ethics. For a franchisor, they must retain ownership or the right to use the brand and to safeguard this for the duration of the franchise agreement. They must recognise their franchisees as independent entrepreneurs, not employees of the franchisor. They've got to train and equip the franchisee in the use of the know-how and monitor its use by the franchisee. In other words, a franchisor has to maintain a vested interest in the success of the franchised business. The franchisor has to invest appropriate levels of human and financial resources to promote and research and develop and improve the whole business. They have to ensure that the long-term development of the concept is assured. They must inform franchisees of their internet, commercial and/or sales policy, and they have to enforce, mentor, nurture and motivate their franchisees. The franchisee, as I've already stated, has to devote its best endeavours to the growth of the business. But because they have to collaborate loyally with the franchisor, they also have to collaborate loyally with their other franchisees. This means that they cannot go and stir up trouble in the network. They have to be responsible as an independent entrepreneur with regards to third parties for their acts within the framework of the franchise itself. They must supply their franchisor with the data on the business, and they must allow the franchisor to ensure the quality of the service or goods being provided by the franchisee to make sure that the concept is being properly maintained. And they mustn't disclose the know-how or breach any of the confidentiality obligations under the franchise agreement. Some of the other key terms that have to be in the franchise agreement are the grant of rights that have been given to a franchisee. More specifically, whether any form of exclusivity is being given to a franchisee, such as an exclusive territory, or whether it's simply a marketing area, and what rights the franchisor wishes to reserve to itself. The duration of the franchise agreement needs to be stated. The length of the initial term has to be long enough to allow a franchisee to recover its initial investment and make a profit. Industry standard tends to be 5 years, in line with competition law requirements, but there are variations to this, and sometimes longer periods can be granted. If a franchisee is being given renewal rights, these need to be stated. These tend to be conditional, dependent on a franchisee not being in breach, perhaps refurbishing their premises, undergoing further training, maybe paying a small fee to renew, but this should not be a barrier to renewal. And then there should be a requirement for the franchisee to sign up to the then current form of franchise agreement to ensure again that as far as possible there is uniformity of contractual terms across the network. It's also an opportunity for a franchisor to ensure that a franchisee is up to date with all of the latest developments in the system. If a franchisor wishes to impose minimum performance criteria on a franchisee, these must be clear and they must be stated in the agreement. If the minimum performance criteria relates to financial performance, then these should accord with the BFA's recommendation that any minimum financial performance should not be more than 70% of the actual average financial performance being achieved by the remainder of the network for the same period of time. This ensures that there's always an objective benchmark against the performance of the franchise network and prevents an unreasonable minimum performance being imposed on a franchisee. The consequences of failing to perform and failing to meet those minimum performance criteria again need to be clearly stated. The BFA expects there to be a staggered approach to failure. Therefore, if a franchisee fails to meet minimum performance criteria, the franchisor should commit to working with the franchisee, putting a remedial plan in place and trying to actively improve the franchisee's performance before even contemplating moving to any of the consequences such as a reduction in territory or ultimately termination of the agreement. The franchisee should have a right to sell their business. This is the franchisee's main exit route, and it's their opportunity to get out of the business with a profit. They have a capital asset to sell. However, the rights to sell the business has to be subject to the franchisor's approval. The franchisor will want to know who is coming into the network, and they must have the right to approve that person. Most franchisors also wish to have a right of first refusal over the business and the opportunity to buy it back should they wish to do so. And in addition, to recover any of their costs that they incur in actually investigating the prospective purchaser or monitoring the sale. Death and incapacity should be addressed in the agreement, and whilst this is always a bit of a sensitive topic to bring up at the outset with a franchisee, it still should not be shied away from. If a franchisee dies or becomes permanently incapacitated during the term of the agreement, the franchisor will want to have the right to be able to supervise and manage the business and ultimately force a sale of it or perhaps buy it back. Therefore, the right to appoint a manager in the event of one of these circumstances occurring should be written into the agreement, together with the basis for any charging that the franchisor wishes to make for this service. The time periods that are imposed on a franchisee before the franchisor can require the business to be sold or for a beneficiary to be appointed to take over needs to be carefully thought out to make sure that the goodwill in the business hasn't diminished over that period of time. In addition, a franchisee must be required to carry appropriate insurance. This is not only for the franchisee's benefit, but also for the franchisor's benefit and the franchise network as a whole. The appropriate risks must be covered off. The other key terms that may need to be thought about and should be in the agreement will be non-compete and confidentiality undertakings that the franchisee must give, both during the term of the agreement and on termination. The actual rights of termination. Typically, these are one-sided. The franchisor has the right to terminate, usually for a whole list of events that would be considered to be a material breach, but a franchisee does not have a contractual right to terminate. This does not mean that a franchisee cannot terminate at all if the franchisor is in material breach. They would always have that right to do so at law. It just means they do not have a contractual right to simply terminate on notice. And this is essential, as a franchisor will want a franchisee to have the commitment to trade the business for the duration of the initial term. Otherwise, a franchisee could simply terminate after the first year, wait out any non-compete restrictions, and then set up in competition. The non-compete obligations that kick in on termination are vitally important, and they need to be very carefully drafted, as this is subject to a lot of case law and is a hotly contested area of law. Typically, a franchisee will be prevented from trading in a competing business on termination for a period of up to 12 months, both from the premises that they were trading from and their franchise territory. Sometimes that non-compete obligation extends further into other franchise territories. It depends on the system, and expert franchise legal advice is required for this drafting. In addition, a franchisor may want step-in rights on termination, so they can go in and take over the business when they've terminated the agreement. Care needs to be taken over how the valuation of that business is actually calculated in those circumstances. Typically, if a franchisor has terminated the agreement due to the franchisee's breach, the franchisee is not entitled to anything for goodwill, and is simply a step in and a buyback at cost value for any equipment or assets that are in the business, and the franchisee stands to get very little. In the event of any dispute between the parties, there should be a dispute resolution mechanism in the agreement, either mediation, possibly arbitration if the parties do not want to go to court, but certainly mediation should be offered, and the parties should be under an obligation to try and resolve disputes in good faith for a period of time before mediation is considered.